Hello, everybody, and welcome to another Phia Group Empowering Plans webinar. I am your co-host, Adam Russo, and pretty excited to be here today. Wait, why isn't Ron sitting next to me?
John Jablon, I think, is sleeping in that seat overnight, taking his spot.
I need you to get up and switch. I can't do this. We've been doing 6 years of webinars, and I don't need to have this the first one where I'm looking at Ron. I can't look at Ron do the webinar. It won't be as good. Folks, we're really glad you're joining us today. It's a horrible day. I think all the nice weather we had in New England and Boston is gone now. I think fall is upon us. If you look at the weather, guys, over the next 10 days, it's like 60s. So it's done. Yesterday was our last nice day. It was 80 degrees, but now we'll all be at work, and it's the fall. It is what it is. It's going to be dreary. It's going to be dark, gray, gloomy until next July.
Football weather, Adam.
It is what it is. Folks, I want to share with all of you something that's really important to us. Jen McCormick, who is a typical co-host here at our webinars, just had a baby, like literally an hour ago, had a baby boy. There is no name yet. I don't think she knew she was pregnant. I don't know. But there's no name. We haven't been told the name. It's a top secret. So feel free to send out your best wishes to Jen McCormick. As of yesterday, she was still doing this webinar. I guess, as Ron said, I guess she could still do it. She could dial in.
She managed the time very well.
I mean, the baby's born. Like, what is she doing now?
Honestly,
but she already has one kid. It's not like something new thing.
Kids should listen in.
Right, she's lazy. So feel free to write to us if you think that Jen McCormick is being lazy today. Folks, today's topic is huge. Back to school renewal time. It's a checklist of everything you need to look at for your renewal period. I know there are many renewals in July. There are some in September. There are some in March. But a vast majority of renewals for your clients and stock employee benefit plans and vendors, your contracts are as of January 1st. So we want to talk about all that today, and we just appreciate you joining us. So who's with us today? As always, it's our Senior VP and General Counsel, Ron E. Peck. Say hello, Ron.
Hello, Ron.
In addition, the Director of Provider Relations, one of our top attorneys, pretty smart guy, especially when it comes to network contracts and dealing with reference-based pricing and so forth. Say hello to John A. Jablon. Say hello, John.
Good afternoon.
I guess it is afternoon here.
You know what? He's sitting
we have West Coast listeners.
He's sitting in Jen McCormick's seat. That's part of why he doesn't just go along with the whole hello.
Yeah.
Hello, John. And last but definitely least, our Director of Healthcare, the guy that focuses on everything we do as it relates to what's going on in D.C. I'm sure he's going to bore us to death today in regards to the Supreme Court pick.
Can't wait.
And the big sex scandal going around. And the guy was in high school. And I guess some new stuff going on with some recent changes when it comes to certain PBMs and as it relates to self-funding. Say hello to Brady Bizzaro. Say hello, Brady.
Hello, Brady.
Perfect. Folks, thank you so much for joining us. Thanks to you for following us on LinkedIn. Just so you all know, we currently have 2,968 followers.
Oh, so close.
Why does Matt Payton still have a job at Phia? He was supposed to get us to 3,000. How many months ago, Ron?
How many months are in a year? I don't know.
12 months? It's been 6 months. But we're getting close. I mean, he's almost at 3,000. Folks, if you have not followed us yet, #save Matt's job for the 4th time. Please follow us at the Phia Group so we can get to that needed 3,000, because once we get to 3,000, Matt is no longer an intern here at Phia and actually gets a paycheck. Very important. Now, why is this important? Phia certification. Folks, we have had 47 employees at Phia already pass level 1, meaning they know the basics of self-funding. We have 7 people who've already passed level 2, which is basically a big deal.
Yes, it is.
We have 7 people already passed. We're hoping that both of these numbers grow significantly by the end of the year, but we're really excited about it, so I thought I'd share that information with you. And again, it is not available to the outside world, at least not yet, but stay tuned on that. We want to give a special shout-out to Michelle Terzic from Advanced Benefit Solutions out in Arizona, right? Is that what she is? We're in Arizona. Do we know exactly where?
Near the air ambulance providers. I mean, honestly.
So we want to make sure we give her a shout out. Michelle, we know that you've been listening to us for years. We know that you've been a great client of ours. Before anyone knew what Phia Group Consulting was, Michelle and her team at ABS were reaching out to us, asking consulting questions of us. It's part of the reason why we decided to actually start a consulting piece of our business. So Michelle, thank you so much for listening.
You know, the slide says avid fan. When I first read that, I thought it said rabid fan.
It could be rabid.
We don't know.
But we will have Matt send you out a very nice Phia Group care package. So expect that in the mail over the next 3 weeks. We will send it very slow. You know, it'll be like, I don't know, like a donkey or a horse. We're not going to spend a lot of money to get this stuff sent over to her. But you'll get it eventually, we promise. Speaking of Matt, our air traffic controller, Matt does not look as good now as he did in that photo. I think we all can agree on that. Would everyone agree?
Yep.
I mean, there isn't a single person here that I go, I want to actually look at this photo. I don't recognize him. Like, I think you need to update the photo as to what you actually look like today. Because I don't have my 18-year-old high school prom pictures up here. So I don't think you should either. Feel free to reach out to Matt at Phia Group. He is the guy to go to in regards to anything Phia related. If you have a problem, you have a question, Matt will know where to send that information and how to get you the help you desire. We need your feedback. Topics. Obviously, we got this month's topic squared away. I think we got next month's topic squared away. Brady's going to give us a little bit of feedback on that. But again, we want you to tell us what you want us to talk about. In this one, we basically took all the top information that people are asking about and also looked at the calendar and said, all right, these are all the problems that our clients continue to have. Let's just tell them what they need to do in the next 3 months to get everything squared away, I's dotted, T's crossed, so we're not helping them with some of this, you know, garbage in January and February of next year. All right, what is the actual overview? Oh, we're actually going to do the welcome video again. All right, how long is this going to take? About a minute? 2 minutes? Folks, check out this welcome video if you don't mind. Let us know what your feedback is. I think we're distributing this now. It's out there. It's on our website. If you like it, let us know. If you don't like it, don't tell me. Let somebody else here at Phia know. But guys, take it away.
Welcome to the Phia Group. We are an experienced provider of healthcare cost containment techniques. We offer comprehensive consulting services, legal analysis, plan document drafting, subrogation and overpayment recovery, claim negotiation, and plan defense. These services are designed to control costs and protect plan assets. We see a big problem for many businesses here in the United States. Employers want to offer top-notch and robust health benefit plans to their employees and their families. But employers are also faced with the high cost of healthcare that continues to increase. As a result, the cost of offering health benefits to employees and their families is too expensive. This leaves employers with a tough decision to make. The employer can either downgrade the benefits or offset the cost onto their employees through higher copays and deductibles, neither of which is a great option. That is where we step in. We try to make health benefits affordable for both the employer and the employee, because hardworking Americans deserve access to high-quality and affordable health care. Our unique approach is to empower plans. That means we help employers maximize benefits, minimize costs, and take control of their own health plans. The way we empower plans is by promoting and educating employers about self-funding. We also invent and implement cost containment services while delivering custom solutions to meet specific needs. Together, we can help both employers and employees save money on healthcare.
Perfect. That went really well. Again, we made a bunch of changes based on the last time we showed this, and we appreciate all the feedback that we got. So this is obviously out there. Feel free to share this with your clients. If you want us to get you a direct link, let Matt know. But there are other services we're doing right now. For example, PDM. We're going to have the training video is going to be animated as well. We're also doing it for, I think, our subrogation process is another one. If there's any of our services, training or legal topics that you want to see a video on, please let us know. Reach out to us. And if we get enough interest, we'll create an animation for that service as well. So I want to make sure we spend a little bit of time and go over what we're going to talk about today. Problem, purpose, people. Political update with Brady Bizzaro, as always. The PGC's FAQs, that is not going to be with Jen. Again, she just delivered a little baby boy. We're going to have John and Brady take over that. Back to school checklist. These are the things that we're focused on renewals, plan docs, TPAs, ASAs, networks, appeals, stop loss. These are the major things that we notice clients making mistakes on, issues with. If you can get them squared away now before renewal season, it's going to make it a lot easier than dealing with it next June or July. Okay, with that, as always, just so you guys know, problem, purpose, people. Why does this matter? We're trying to focus on the millennial generation. Folks, as many of you know, this Sunday night is the start of SIA, happening in Austin. A year ago, there was no Future Leaders Initiative. I know Brady Bizarre is on the committee, the Future Leaders Committee at SIA. So a year ago, there was no Futures Leaders. A year ago, there was no idea on how we can actually attract young people to come to SIA or join it or be interested in self-funding. I am glad to tell you that as of this morning, we have 210 attendees just for the Future Leaders session.
Really?
210.
It's impressive.
I know it's impressive. I'm going to pat myself on the back on that one.
There you go.
But I want to thank all of you out there who decided to send someone. And if you haven't decided to send someone yet, you can still send them. It's going to be an amazing event. It's at a low cost. And the focus is of this particular initiative is to get our young people involved in self-funding and interested in our industry. And feel free to share this slide as why it is they should care about self-funding. Why is it important to be involved in health insurance? Because what we're doing is giving Americans access to high-quality, affordable health care. So with that, I'm going to turn it over to John first to talk about what the most frequently asked questions were to our Phia Group consulting team. Take it away, John.
Thanks, Adam. So this first Phia Group consulting frequently asked question, I don't know if this has seen an increase because it's the summer or the end of summer or because school's about to start, but we've been getting a lot of questions about alcoholism and alcohol-related exclusions and injuries. And one of the questions that we've gotten a lot of times recently actually is about pending or denying claims for alcoholism until the patient actually signs a form essentially validating that, the cause of the injury and things like that. And one of the main things to keep in mind when you're looking into alcohol-related exclusions, which most plans have in some form or another, is the Department of Labor's what they call the source of injury rule. And essentially, in a nutshell, that rule says that if claims are incurred because of alcoholism, so it's a medical issue. So claims are incurred because of a medical issue, and that includes alcoholism, then they can't be denied just on that basis. So if there are other reasons to deny the claims, by all means, process them normally. But if alcoholism is the primary reason for denying the claim, you're always going to see an issue, and there's always going to be more research to do. So for any plans there that are kind of looking for reasons to deny if you suspect alcohol is involved, think twice before giving a blanket denial because it might not be quite that simple.
I think we should just call this entire slide the Josh Gordon slide. If you look at it, we have alcoholism, we got marijuana.
Very timely.
There's no cocaine on this one, but my beloved Browns just gave him to the. I guarantee you, now that he's on the Patriots, he's going to be like an all-pro.
Oh, he's going to be a saint.
This guy will never drink again or do drugs again. Anyways, sorry about that, John. I saw the slide and it just made me think of it.
The Patriots Health Plan Administrator is actually listening, so they want to understand what to do with the exclusion.
So before I turn this over to Brady for the other two questions, I will note that we actually just got a question, and it's an excellent question. Does that apply to suicide? Our general advice there is yes, because suicide is a medical issue, and depending on the circumstances of the claim, everything is very fact-specific, as most of you probably know in the self-funded industry. But in general, yes, suicide is generally considered to stem from depression. And if you see a claim for suicide, you can bet that the member's family will find a doctor who will be able to say that it was caused by depression.
John, we're looking here at alcoholism, we're looking at drug abuse, but you might recall, and this has been an issue for many years, a lot of benefit plans, at least they used to have an exclusion for self-harm. Somebody who injures themselves, that was excluded. And that was a very good blanket exclusion. And this issue of source and medical conditions and also being a victim of domestic abuse is another one. When it came to self-harm, it became a major barrier to applying that exclusion. So I think we're looking at the same thing here. And I know that a lot of plan administrators in response to that, what they were doing is they were looking for some sort of documentation or evidence that there was a medical condition, including psychological as well as medical. And that kind of goes to what you're saying, which is that especially in these instances, it's fairly simple to find a provider that's willing to testify that, yes, indeed, this person was suffering from some sort of a medical condition.
Yeah. Yeah, absolutely.
So for the last two questions, and this is Brady, I'll address them briefly. I think like John said, it's summertime. Maybe that's how we're getting more questions about marijuana use or CBD oils and such. But at this stage, you've got 29 states now who have legalized medical marijuana. So we get asked the question all the time, can a group exclude the use of legalized medical marijuana? And if they wanted to cover it, what considerations are at play? And there are many. So first thing to note is that our position, at least formally, is that we don't recommend that you cover medical marijuana because it's still a federally illegal drug. It's still classified as a Schedule I drug. Whether or not it should be, it is. The same category as heroin, ecstasy, not a good deal. So if a health plan were to cover the drug, it would be violating federal law, and we don't recommend that you do that. Also, the FDA has not approved marijuana and other derivatives of marijuana for any use. So if you're offering coverage for these oils and other CBD products, same problem. And this is despite the fact that it may be legal in different states. It's essentially an issue of state versus federal law, and it's still illegal federally. There are cases, though, in the courts where the use of medical marijuana has been deemed a reasonable accommodation under the Americans with Disabilities Act. So interestingly, in the employment realm, in other words, outside of the health benefit realm, there may be cases where if an employee of yours is using medical marijuana not covered under your plan, think twice before you take action against them. Many states have protected the use of that drug. But for purposes of coverage under the health plan, we don't recommend it. Also, if you are going to go ahead and cover it anyway, there are many other things to consider, one of which is you probably have in your plan already an illegal acts or illegal drugs exclusion. That's going to conflict with covering medical marijuana. Check with your PBM. Your PBM contract probably has a conflict. And, of course, probably as importantly or even more importantly, stop loss, right? Stop loss is almost certainly not going to reimburse claims for medical marijuana because you can bet if we have concerns with plan sponsors covering an illegal drug, they have concerns with covering as well.
One of the things we have to look at as well on this is if it's a union plan, they might have their own rules in regards to what's allowed. You know, they do drug testing and no drug testing, et cetera. So, again, federal law, state law, what's already in a particular contract when it comes to, organized labor, so forth. That's all something to be considered. Right.
Also, we're seeing questions here, and I just want to quickly answer them without wasting too much time, regarding whether if a person is injured in some sort of an accident and alcohol is involved, can they use these exceptions in order to avoid the exclusion? And it's important to note that alcohol-related, drug-related, self-harm-related exclusions, that's separate and distinct from an illegal acts exclusion. And it's also, and the argument's been made, and we've supported it, and we've provided some consulting and arguments, ghost written letters that can be used in the appeals process and denial process, that while it may be that a medical condition such as alcoholism drove a person to drink, it didn't also require them to get behind the wheel and drive. And so it's important to note the distinction between the abuse of alcohol and injuries and illnesses that arise from that abuse, liver failure and things like that, versus actually being in a car accident where you were driving under the influence, which is a separate and distinct issue. And then also, very good, suicide or attempted suicide, a dead person probably doesn't incur that many medical costs. You'd be surprised. They're still willing to fly a helicopter in there and med lift somebody just
right. Someone can die on the way to the hospital.
Yeah, right.
But they're still in the air transport. Yeah. That expense is still going to be there.
You bet.
We've seen too many of those.
Really quick on this last question here. It's actually an important question, and we've gotten a fair amount of times, obviously, here. Does the ACA impose any age requirements for the use of anesthesia? In particular, this came up in the context of dental anesthesia for children. So many children have apparently many dental problems and issues, and the dentist would recommend the use of anesthesia. And there's many articles about dangers to children, and children tend to get put under more deeply than adults do, and there's a lot of risks associated with that. But this is really a question about essential health benefits and federal versus state law, because as you'll recall, the ACA created a framework for EHBs, and as a self-funded plan, you've got to select a state that has certain EHBs, and if you cover any one of those essential health benefits, you can't impose dollar limitations. Also, if you select a state with a certain benchmark plan, that benchmark plan is going to, or not, cover dental anesthesia. And the state that you pick will have, very likely, its own rules about age limits or other restrictions about the use of anesthesia in children. So the short answer here is that this is going to be a state-by-state question. And so look at the state's benchmark plan that you've selected. And if dental anesthesia is on that benchmark plan, then look to the state laws to figure out what restrictions, if any, apply to the use of anesthesia in children. But it is an important issue, and we wanted to mention it. So more importantly, in my view, than these questions is the political update. And we're a little crunched for time, but I'll do my best to make sure that we cover this in full. The Kavanaugh hearings, as everyone I'm sure knows, happened a couple weeks ago. 32 hours of questioning over 4 days. You can bet that I watched every single hour. I'm sure Adam maybe caught a couple of the reruns. But a big deal for healthcare. He's a swing vote on the court if he gets confirmed. I'll talk about the potential curveball that's interrupting that in a few minutes. But these hearings were interesting. A number of the Democratic senators were pressing him on questions related to the Affordable Care Act, related to abortion rights, other women's health issues. And there are some serious implications here, I think, for our industry and really for even the fully insured industry. What you saw if you watched the hearings is, and as most of these nominees do, they don't directly answer questions. They don't answer hypotheticals. It's really tough to get any questions or any answers out of them. But the effective questioning came from certain senators who analyzed the nominee's judicial record, who were looking at his prior written opinions and the law review memos he's written about the Affordable Care Act, about abortion rights, and there were some things there. So what you saw was, I thought, some astute senators questioning him on the use of certain phrases even. But looking at his judicial record on the ACA, what can we tell from it? We can tell that in 2011, he basically ignored the ACA. He sort of punted. He didn't rule on the issue because the mandate hadn't gone into effect yet at that point. 2015, he dissents on a technicality saying the mandate's a tax, but kind of punting, actually very smart to do if you're a nominee who eventually hopes to get picked for a Supreme Court justice. So that's what he did. 2015, he weighs in on the contraceptive mandate cases, which are still important to this day, obviously, and notes, as you would expect from a conservative-leaning justice, or judge in this case still, that one should not question sincere beliefs or grounds that employers may have for feeling complicit in birth control that they may find immoral. So you can guess how he'll end up on that particular issue. His public record on the ACA, again, I mentioned he wouldn't commit to hypotheticals, and the particular concern is here how he'll rule on a potential case that attacks the ACA's requirement that you have to cover people with pre-existing conditions. Kavanaugh apparently, some of the writing suggests that he may not think that's the case, but privately, he has told Democrats that he doesn't think the entire ACA should be struck down. And there's currently a case in Texas, which I'll talk about in the next slide, which really poses that kind of a threat. He's actually been skeptical on the Texas case. Whether or not he's serious about that, we'll find out. But it's safe to say that on the ACA, he's not a big fan, but it seems like he's not calling for the entire thing to be abolished. On abortion rights, however, it's a bit more confusing, and a quick summary here is that he's used the phrase existing precedent when talking about Roe versus Wade. He didn't do that in other cases. That might imply that he thinks that at some point the case could be overturned. There's a particular exchange with Senator Blumenthal I wrote about in my blog. It's on our website if you feel free to read it, see some of the questioning. I thought he was very, very clever, though, in how he really got the nominee to sort of play his cards about what he really thinks about the abortion issue. So more broadly than Kavanaugh, though, there are 5 key areas, I think, here that are at stake for healthcare with this new nominee to the court. He'll be ruling on many cases about the ability of courts to strike down entire laws if one piece, like the individual mandate, is found unconstitutional. How will he rule on that question? We'll have to wait and see. This one's pretty important. Can a take care clause of the Constitution be enforced against the president? That has to do essentially with the president's requirement that he takes care to faithfully execute the law. Anyone who's been following politics or our webinars knows that the president has actively been trying to undermine the ACA. He's been calling for its repeal from day one. So there are some states and states attorneys general who have filed suits against the administration saying he's violating the Constitution. He's not upholding the ACA. He's attacking it. So it's kind of a big deal. We'll see how that question gets resolved. Similarly, number 3, what if he decides not to enforce the law at all? He says, I don't believe the ACA is constitutional. There's some writing from Kavanaugh and a dissent he wrote where he actually said that a president could, if he feels the law is unconstitutional, not enforce it. That's a big deal. So if a case like that reaches the court, we'd expect him to be on the side upholding the president's authority. 2 quick ones I'll just mention briefly here. Can individuals sue the government to enforce their rights? Some of that has to do with Medicaid, but also with the ACA. Can private individuals sue the government if they find that they're not enforcing the mandate, if they're not enforcing the ACA coverage requirements? We don't know how Justice Kavanaugh would rule on that issue. And finally, should courts allow federal agencies to let states undertake these projects to alter fundamental aspects of programs? That has to do with Medicaid work requirements, not so much with us, but I think it's worth noting that this could apply to some agencies that are tasked with enforcing the ACA, like the Department of Labor.
Before you go forward,
Sure.
Brady, you're always wrong.
Sorry, I'm all wound up.
Brady's always wrong on his fortune telling, right, Ron? We know that.
One time he foretold that he'd be wrong
So he was right
Correct.
there.
So
I like
based
that.
on the recent allegations from some party in high school,
Yeah.
will he become a Supreme Court justice or not?
Man, you're getting ahead like 2 slides, but I guess
Oh, I am.
Yeah, I do have a little bit on that, but I'll say.
Well, I know the chaos.
Can I save it? Yeah,
I
it's
see the
chaos.
chaos. No, I think it ties into this.
Sure.
I mean, we're talking about what he's going to do, what's going to happen.
Sure, I can address that quickly.
Will he even be there?
I think, look, this is a big deal. The person's going to testify. The vote in the committee was supposed to happen Thursday. The Republicans control the committee 11 to 10. Now some key Republicans say, hey, hang on, we're going to delay the vote. The vote's been delayed. There's a hearing on Monday with the accuser, with Kavanaugh. It's going to be a circus. It's going to be like
she acknowledged
the
that
Hills
she'll
in the
be there?
90s. She'll be there. And they're calling up his old girlfriends to testify. It's going to be, I mean, I'll be watching. I hope you don't mind while I'm probably here.
No, I need you to work.
I'll be at SIAS, so maybe not. But so I think what's going to happen, we'll see how this plays out. If it's found that he lied under oath to members of the committee, there's no way he gets confirmed. What happened to Clarence Thomas, who faced similar allegations, is it was a narrow vote, but it was a bunch of white men on the Judiciary Committee back then. Now you've got a number of women, including Dianne Feinstein and Kamala Harris from California, and really, really tough Democrats, and we're in a different environment now. So these allegations have really derailed, big-time people, from CEOs of massive
So again, what's your answer? We need to know what you think's going to happen.
Like a true lawyer.
Right. What is actually going to happen? You just say, yes, he's in, no, he's not.
I think he skirts by. I do.
So that means, yes,
Yes.
he's in.
Yeah, I hope I'm right.
Skirts by.
I
Yes.
hope I'm right.
Good. All right, now feel free to go to the next case.
Quickly, I'll talk about this Texas case. We've covered it before, but a new development's happened where there's been oral arguments that have been held in the case. This case is one that's filed by 20 attorneys general from various states, led by Texas. It's always Texas, huh? That's challenging the ACA here. But it's a case about severability. It's about, look, the individual mandate, the penalty's been zeroed out. Now they're arguing that it's unconstitutional to keep it as part of the ACA. It's been zeroed out by Congress. And they're arguing that if you get rid of the individual mandate, the rest of the law has to fall. And the Department of Justice has agreed with the plaintiffs. They're not defending the ACA, which is pretty insane. And so the defense of Obamacare has been left up to Democratic attorneys general from 16 states and D.C. So it's really a weird set of parties at play here. The question here for the judge is whether he will issue a preliminary injunction against some or all of the ACA. And what the judge has said is that he'll rule on this, quote, just as quickly as I can. We'll see when that happens. But really, a ruling that strikes down the ACA, which will be appealed, but even a ruling initially will throw the markets into chaos, I think. So we'll have to wait and see. You can read more, if you'd like, about the Texas case on our blog. We've talked about it before, but the oral arguments seem to indicate that the judge in Texas in this federal district court seems to think that at least some of the ACA could be thrown away as a result of this case. And this case could very well make its way up to the Supreme Court. We're watching to see how that happens, and we'll be following it. A few very, very quick honorable mentions. I know we're pressed for time, but I mentioned before that there are lawsuits on the opposite side of this issue here, accusing the administration of a death by 1,000 cut approach against the ACA, saying it violates the president's constitutional authority and duty to uphold the law. There's one about short-term health plans. As you recall, the new rule was issued recently on short-term health plans. They don't have to follow many of the ACA requirements. That's a threat to the individual exchanges. It's going to peel people out of the exchanges and into these short-term plans and association health plans. That's going to further undermine Obamacare as a whole. So there's a case about that. Really quickly as well, the House is voting on legislation which would change the definition of a full-time worker. That's big news. I don't think it's going to pass the Senate, but it would effectively change the requirement down to 30 hours from 40.
So you don't think this is happening? Because this will have a major impact on.
We'll see after the midterms. I mean, that might change things, but it'll probably pass the House, which is solidly in Republican control for now. But it probably won't pass the Senate. But it would really, it's meant to erode the employer mandate. It's starting to get at that, and that's what we're seeing happening next with this bill. But I'm not sure it'll eventually pass. We'll know more after November. We'll follow up on it.
So this will be a topic that you will address in December during our webinar then.
Absolutely, yeah.
Because obviously, if you're a self-funded employer, if you're a TPA, and right now you're administering 30,000 employee lives, technically, you might just lose business because your clients will have less people covered under the plan,
right?
Technically.
They'd be upping the hours to 40, and many people who were previously covered under the plan wouldn't have to be covered.
Right, so that employer might say, hey, you only work 35 hours a week, you're not working 40.
Really big in hospitality, restaurant, hotel, where the hours are flexible, limited.
Right, or they have to increase the number of hours that people get to work. So now they'd be paying more in wages, more hours they're paying for, and then they'd be covering, whereas now they could say, I don't have to cover you anymore, you don't have to have any insurance.
Right. Yep,
so it could hurt.
It could.
On the industry.
It absolutely could. I think we'll have more to say both on this. I expect to see other actions taken against the employer mandate too in the coming months, so we'll follow up with that. I talked about the chaos that's going to happen.
Yeah, we got
on Monday. So with that, I'll talk about one more quick thing, which is a big bombshell, I think, that dropped yesterday.
This all happened yesterday. So Brady, kudos for putting this slide together really quickly.
Sure, no problem. So this slide here just shows you the crazy increase in specialty drugs once they get to market, how much more expensive they are when they first get to market. This is from CVS Health. They looked at particular oncology drugs, very expensive drugs, and look at the trend. I mean, it's insane. There's been inability to contain the cost. We talked about back in May how the administration had a bunch of bold new moves. We have to give them credit, I think. The president may have called out some companies in his tweets, but like dozens of companies have reduced their prices voluntarily. On top of that, you now have a PBM, one of the biggest in the country, CVS Health, who's now launching a new program where they would allow self-funded plans to
just self-funded.
For the moment, just self-funded plans.
Right.
Who use them as their PBM to exclude certain drugs if the list price at launch time is too high. In this case, they set a number. I'm not sure how they came up with that, but it's $100,000, what they call a QALY, which is a quality-adjusted life year, meaning the year that a patient on this drug undergoes some quality measure. But if that value is higher than $100,000, they would not have to cover it except for these breakthrough therapies, which are experimental at some point.
So bottom line, right now, this was a big move by CVS.
Yeah.
A breakthrough.
Yep.
Other PBMs might follow just based on market requirements, et cetera. However, this would give certain self-funded plans options to reduce overall costs that right now they don't have.
Absolutely. And puts tremendous pressure on manufacturers to
lower the prices. So this could be good, it could be bad, and we're going to discuss this extensively in our next webinar. We're going to tie it into PBMs in general, I believe, just talking about what some of the trends are. But clearly, as a self-funded employer, this could be great news because now you are putting pressure on manufacturers to go, hey, listen, whereas before, we were covering everything. So you could put any price you want on it. Right. CVS came to the table and said, hey, guess what? If you don't basically reduce your overall prices, we're not going to require our self-funded clients to actually offer these drugs. That's a big step.
We actually just got a question, and it's a really good one. The question is basically, but can't a self-insured plan limit drugs by price anyway, any price level they want? It's a fantastic question, and we see that question in the context of pharmacy and specialty drugs, but we also see it in the PPO context. And the idea is that a lot of PBMs set a formulary and basically say, hey, self-funded plan, when you sign with us, you use our formulary. Sure, the plan can put whatever language it wants in the plan, but is it going to be violating its PBM contract by actually applying it? Right. Maybe. This program by CVS is essentially changing their formulary so that a self-funded plan doesn't need to worry about possibly violating its contract if it wants to exclude these high-cost drugs.
One quick thing, too. I know we're getting more questions on this, and that's why we're going to cover it.
That's why we'll have it on next webinar.
Someone asked, what about essential health benefit rules and, imposing dollar limits? Good questions. That's going to be a good question and challenge to this program. We'll talk about the pros and cons and the risks associated with it next month because, frankly, Ron can't wait to jump in and talk about plan documents.
Yeah, right. That's exactly it. No, listen, I could talk about alcoholism and drugs and pharma all day, but we're gonna talk a little bit about plan documents.
Before you start, Ron, I want everyone to understand to look at this as a checklist. These are the things you want to make sure you look at between now and the end of the year, or between now and the time you actually renew or sign on a new client. So if you're bringing on a new client, and that client is renewing. These are the questions that Ron's going to go over that we want to make sure you can answer yes or no to before you move on to the next step. So, yeah. Ron, take it from there.
So, your entire plan, its foundation is the plan document. And one of the things that we frequently see when eventually a client does send us a plan document for review and revision is that it's not necessarily non-compliant, but the problem is it's non-compliant because it has dozens of amendments that have been pasted onto it through the years. So every time there's a new regulatory requirement, rather than revise the plan document, they issue an amendment. And while that may technically be okay, the more moving parts you have, the greater the opportunity for there to be some sort of a gap or something is missed. Not to mention the fact that it makes it much more difficult for your plan members and for the administrator to actually apply it. So eventually you need to stop yourself from just tacking on and duct taping new amendments onto the plan and revise the plan. So while I'm asking you really two questions, when was it updated? Many people say it was updated last year. Yeah, it was updated last year when you passed new amendments to a plan that's been in existence for a decade. When we talk about updating, it's time to take those amendments, take that plan document, revise the whole thing, issue a brand new clean plan document. Very important to restate. And as Brady's been talking now for the last half hour, and frankly, every webinar we've done in, I don't know, the last 2 years, he spends the first half hour talking about all these changes in law. You probably get the sense that a plan document from 10 years ago is probably not compliant today.
So to go back to what Brady was talking about earlier, the changes now with CVS and we're seeing in the marketplace, it could affect your SPD going forward.
Absolutely.
That is something you have to look at. And then, Ron, as you know, over 90% of our SPDs that we look at do not match the employee handbook.
Correct.
Ours didn't.
That's assuming you even have a handbook, which I don't even want to go there right now.
You're better off not having one
Sometimes.
if it's not going to match.
So assuming that you do have a handbook, I mean, everybody knows that the handbook is written more often than not by your HR. It's a very internal document. You have meetings about it. You talk about how much PTO are we offering? Are we drug testing? Meanwhile, your plan document, if you're an employer, chances are you've pretty much outsourced that to your TPA, to a carrier, to a broker. So it's not even the same people, let alone the fact that it's not the same document.
Right.
So it's extremely important to compare the two and ensure that they meet each other, that there's no gaps between.
And quickly, before Ron talks about the compliance piece, just to look at, what we do here at Phia is look at both the cost containment language and the compliance language. We know is this, these are the stats, roughly 1/3 of all plan docs we get to review are not compliant with law, either state or federal law, literally not in, or the ACA. They're just not in compliance, or the DOL. About 60% are one big claim away from blowing up the entire self-funded plan. That's the cost containment. So they're two different things. When we do our report cards, we have one report card for compliance, one for cost containment. You can have a very compliant plan doc written by the best attorney in the country, but literally you're paying every claimant 100% of bill charges. That's what we mean by SPD. Ron, let's talk about the compliance.
Okay, so when we're talking about compliance, and Adam, you just touched on it, there's really, I think, two levels of compliance. There's legal, and then there's intelligent. We see plenty of legal plans. We don't see that many intelligent plans. When we talk about a legal plan, it means if you were to look at the pure law, is it compliant with that law? The answer is maybe, right? Okay, it's legal. But you could legally be forced to pay a claim that the plan can't actually afford, and that's where intelligent design comes into play. And I'm talking about the intelligent design of a plan. Although sometimes I feel like we're playing God. So when we look at a plan document and we look at an intelligently compliant plan document, it means, are you meeting, for instance, the requirements of the exclusion? We talked about the illegal acts exclusions, right, and the drug abuse exclusions. And we talked about how the source rule comes into play. And this is a great story that we've talked about for years now, was the domestic violence being the result of domestic violence, and the fact that there was that guy who broke his hand beating his wife, and the claims come in for the broken hand, and when they tried to deny it, he said, well, no, it's the result of domestic violence, and they had to pay the claims. Was that plan legal? Was it compliant? Sure was. Was it intelligent? Heck no. So now we've amended the language to say being the victim of domestic violence. That's the type of thing we're talking about when you're combining both compliance and cost containment. So one, is it taking that kind of cost containment, looking at the different potential scenarios and actually addressing those scenarios preemptively? That's an issue. If you're doing so, did you do it by amendment? Okay, great. It's been amended, but it may have been lost in the mix. Just like I said, eventually you have too many amendments, too many patchworks. It's time to come up with an entirely new restatement. When you talk about the types of employees, and you could skip down to discrimination, there's obvious discrimination, but then there's subtle discrimination. Saying that, we're going to pay for this type of claim for one type of person.
We're not going to talk about surrogacy again.
No,
let's just end.
Yeah, Jen is not here to bring that up, so let's skip it. So some of those things you look at it, you say, well, that's obvious. But what's amazing is I think a lot of people don't understand that there are ways to be discriminatory where it's not obvious, and yet for someone who's dealt with a lot of these scenarios, it becomes obvious. For instance, we were just talking about the specialty drugs, right? And people are saying, well, can't we put caps? It's amazing to see that sometimes if you try to put a cap or a limit on how much the plan is paying based on a condition, that could be discriminatory. Whereas if you put the same exact cap on the treatment, it's perfectly fine. Now, from a layman's perspective, you look at it and say, well, what's the difference between putting a limit on, let's say, end-stage renal disease versus dialysis? Isn't it the same thing? And yet, legally speaking, if you're putting a cap on end-stage renal disease, it's discrimination. It's illegal. If you're putting a cap on dialysis, it's not. Same end result, but the semantics matter. And how do you know when something like that is going to matter? You need to have someone who's dealt with these situations explain them to you, otherwise you wouldn't know about it.
Before we get back to John, I want to answer a couple questions. I know people are asking us for more details on the whole CVS situation, what's going on. Hey, folks, it literally came out yesterday. We have to still vet through all the different options. We're going to look at our template plan language to see what people are doing now, what we recommend. So next month's webinar, we'll have an entire, here's what happened, here's what's going to happen, here's how to prepare for it for January 1. We cannot do that today. It literally came out yesterday. We're going to revise. We want to give you real wording, real language, real things you can put in place. But this is an option now. And again, no one here is saying that it's a good or bad thing. It's something that's happened. And we're here to share the news of what's happened, put it out there, and explain what the plan's options are. You as a TPA, you as a broker or advisor, you need to be able to advise your client. This is what's going on right now. These are your options. Here are the pros and cons of each. So with that, based on what I just said, when we look at what you're offering and what your plans need help with, what we just talked about next month's webinar is one of those things. But I think what John's going to talk about right now, if you look at it, really all goes back to one very simple thing. Many of our clients, many of the people on this call still have very antiquated administrative service agreements that can be cleaned up really fast. If you have not updated your ASA in the past 2 years, just pick up the phone or email us, and we'll show you what type of language you need to have in there, because we've worked with over 150 TPAs and created the best language possible. So with that, John, take it from there.
Yeah, thanks, Adam. That's actually a really great segue that you mentioned. You know, if you haven't updated your ASA in about 2 years, well, it depends on what you're doing. We see so many TPAs out there in the industry that change their processes so often based on client demand, based on broker demand, based on market demand, that you might need to update your ASA more often than every 2 years. Basically, you need to just make sure that whatever you're offering is in your ASAs. So one of the main things that we do face very frequently in our Phia Group consulting department is issues about handling claims and appeals. Now, if you're a TPA, you're obviously in a different boat than if you're a broker, right? If you're a broker, you've got a group. You need to make sure that the group's claims and appeals are handled correctly. Who's handling them? Is it the group itself? Is it the TPA? Is the TPA making the actual decisions? Well, if you're a TPA, you need to scrutinize this even more closely, because there's always potential liability there. So how you handle claims and appeals is largely dependent on what you have the bandwidth for, what you choose to do, what your typical business model is. It varies from TPA to TPA, but just remember that handling claims and appeals is very dangerous if you're a TPA. So while you can do the administration and fill out the paperwork, it's always a best practice to make sure that the plan administrator is the one who actually makes the decisions on claims and appeals. And of course, it is the case that the average plan administrator doesn't know anything about making determinations for claims and appeals.
So we're going to talk about a lot of the appeal stuff in a couple slides, right? So I know that that's important. How about stop loss? What are the issues there?
Yeah. Well, obviously, one of the main issues is who is placing it and who is responsible for placing it, and who is responsible in the event of a stop loss denial. We've all seen stop loss denials. Some are perhaps more warranted than others. It depends on the carrier. It depends on some circumstances. But basically, if you're a TPA and you're placing stop loss, you can reasonably expect a group to push back when they get an unexpected denial. Because as the TPA, you're the one who kind of made this introduction. You're the one who brokered this deal. Even if it's legally unwarranted, it's understandable that a group would be confused and need to look towards someone who can help them, and maybe even someone who can foot the bill for a claim that they thought was going to be paid. As for network and provider disputes, it's kind of along the lines of the same as stop loss, because generally the network and network provider issues, they stem from the TPA as well. Normally what happens is the TPA allies with a network and then passes that access on to groups. They lease that access to groups by way of the network. So what happens when network rates are, in a group's opinion, far too high, or in a broker's opinion, or even in the TPA's opinion? Who is responsible for that? Who is dealing with it? Who is in the trenches fighting with those medical providers and trying to negotiate better rates with the networks? That's one of the things that we're going to be talking about in a couple of slides from now. But it's one of the primary things that it's a great time to look at when it's time for renewals, because if you're looking at your current network and it's a big national network, well, chances are some of the other big national networks have those same providers in them. And the problem is, if you're in a network that is really a bad fit for you, once the new year rolls around, it might be too late to change. Recovering overpayments is a great topic and one that we've been dealing with a lot over here lately. And it's we deal with it both from an actual recovery standpoint and from a liability standpoint. And the liability is because brokers and groups look at TPAs and say, you know, this was an overpayment. It doesn't matter the reason. Some are TPA error, some are network repricing errors, some are, you know, eligibility files having very slight delays. Anything can happen. Nobody's perfect. The industry has so many moving parts that overpayments happen. Simply put, they do happen. There's no way to avoid all overpayments. But is the TPA responsible to recover those overpayments? Is the TPA responsible to try to recover those overpayments? What happens if an overpayment is not recovered? These are all things to look into, and typically these are things that are covered by the ASA, and if they're not, we certainly recommend that they become covered by the ASA, because everybody needs not only to protect him or herself, but to know what's going to happen in any given situation. And last but not least, percent of savings fees. This is a topic that has actually been coming up more and more in the context of state departments of insurance as it relates to TPA laws. So that the laws governing how a TPA is formed, what TPAs can and cannot do. Some states prohibit TPAs from taking percentage of savings fees in some scenarios. So it can get a little complicated based on what you're doing and what the fees are for, but the bottom line is you may want to revisit your fee structure, and if you need any help understanding the laws and figuring out what's going on, feel free to call us.
So when you're talking about the ASAs, let's go back one.
Sure.
Again, all the stuff that John just mentioned, look at your ASA to see if it protects you and as it relates to these things. If you're not placing a stop loss, we have a one-page, what do we call it?
So that's actually something we're going to talk about.
Oh, it's a one-page what?
So we do have a one-page, it's basically a waiver. It's a disclaimer. And in essence, one of the things that John talked about is the liability if the TPA did place it, but just as important is if you didn't.
Right now, a majority of brokers are the ones placing the stop loss, but yet TPAs haven't updated the ASAs to see that reality. Right now, it's almost still based on as if they're the ones who place the stop loss, so that's important. So the ASA needs to protect you on the appeals piece, stop loss piece. Remember, on appeals, you might not want to do pre-service appeals anymore. You can outsource that. We're going to talk about that in a second. What the network disputes, who's responsible for those, as we see more and more of these. Overpayments, it is something no one wants to talk about. Who's responsible and how many opportunities, how much time and opportunity does the TPA have to try to recoup those funds before they're found responsible by the particular plan. And again, back to what you just said, John, percent of savings fees. So networks.
Thanks, Brady. So as I just mentioned, and I said we would talk about in a couple of slides, renewal time is the perfect time to analyze your network and see if it actually makes sense to keep it. So are your network access fees going up? Well, probably. That's what we see so many times at the start of years and at the start of new contracts. The fees are increasing, and yet the value somehow stays the same or decreases, or at least that is what is going through the grapevine. And is the juice worth the squeeze? And what I mean there is, of course, are the discounts and the prompt pay, is that all worth the network access fees? You're protecting patients, absolutely, but at what cost? If you're paying claims at a specific percentage off billed charges, well, are those billed charges increasing? Probably. That is the trend that we've been seeing. If a percentage is set and the charges that the percentage is off increases, you're essentially paying what bill charges were last year. You know, it's a lot of measurements involved in knowing whether a network contract is worth the squeeze. And what most people are finding is that they're really, really not.
Oh, and in addition, they might look at narrow networks. They might look at replacing wrap networks. There's a lot of different things. We can go into this for hours. But at the end of the day, you want to make sure of is, does your stop loss carrier reimburse the same way you have to pay the claim if it's an in-network claim? That is something very important, regardless of what you're doing.
Yeah. And lastly here, claims being retroactively adjusted after the stop-loss payment deadline. That's an issue that we have seen just a couple of times now. It seems to be coming up in the industry. Hopefully it won't happen too often. But basically, after stop-loss requires that a claim was paid, the network then comes back and says, actually, plan, you have to pay more. Well, stop-loss wasn't too happy about that, and that's all I'm going to say on that topic.
Before we get into this slide, John, I want to make sure we tell people, a bunch of people asking how do they get access to our ASA. We can obviously give you a copy of the best ASA that we see in the business for about $750, or you can have us redline your current ASA for less. It's about $500. However, you're going to get a lot of the innovative stuff that we put in there. So, right. But how it ties to this, very important. Everything you want to do in your ASA, look to see what you're doing now on out-of-network claims. Are you paying it based on your plan doc as UNC? Are you using a vendor, a wrap network? Are you carving out stuff? Folks, if you want to do carve-outs for dialysis, air ambulance, etc., make sure that you legally can do it, not just in the plan doc, but actually in your network contract.
Contractually, yep.
Did you already agree to pay a dialysis claim with a 20% discount? If you did, it doesn't matter if your plan doc says Medicare plus 140. That is probably the number one thing we can share with you when you're looking at your renewal season. What does the contract say? What does your ASA say? What does your plan doc say? What does the stop loss policy say? John, anything to add to that?
No, because Brady took a half hour. You summarized this slide very well.
We had to. Brady just took it over. So appeals. Ron, explain to these folks the differences here on pre-service, urgent care, post-service. I know that you know this stuff big time.
I do.
So what they could potentially do.
All right. So you'd be amazed what I can get done in 5 minutes, Kai. So first of all, stop talking about appeals as if they're all the same. All right. Deadlines are different. The standards are different. The fact that some are more legal-based or plan administration as far as interpretation of the terms, exclusions, whereas a lot of the urgent or pre-service are going to be much more clinical and they're going to be based more on the medical factors. So the question then becomes, A, what resources do you have available to you? When it comes to clinical resources, do you have a nurse on staff or do you have an IRO that you outsource these to? If so, are they beholden to the same timeline and deadlines that you are? So there are a lot of questions that you need to answer on each type of appeal. Second, when you look at the trend that we're seeing in self-funding in general, you're finding a lot of employers, particularly small groups, who have been fully insured, traditional full insurance in the past. So they're not accustomed to playing any role in the appeals. If a claim comes in and it should be denied, they have nothing to do with it. The carrier denied it. If the patient is appealing, they never saw it. They never had any say in it. And thus they could point the finger and say, sorry, it's the insurance company that denies the claim.
So one thing to understand, on our PACE service, when we do final level appeals, there's one price for that versus a separate price if it was a pre-service appeal. On pre-service appeals, like you said, Ron, while these are clinical, it's 48-hour turnaround, 72-hour turnaround, and that includes weekends. So it's not a situation on a normal appeal where you have 30, 60, 90, 180 days to give a response. On these it's life or death. So if somebody sends in a pre-service appeal on a Friday, someone needs to work that particular weekend. So when you're working with your external IRO, whether you have opportunity to work with someone like Phia on this, understand and know that they need to understand there's a timeline. Because when you're doing your ASA and when you're doing your renewals, your employer groups are expecting that you're going to be working on a Sunday or a Saturday on these pre-service appeals. That is very, very important. So Ron did a great job explaining the differences, but I want you to understand the urgency from a pricing standpoint. They are very different things, priced very differently, and one is much faster turnaround than the other.
You know, if anyone ever says, how do you handle appeals? The first thing you have to ask is, I'm sorry, what's an appeal? Because there's no such thing. There are many different types. And the last thing I want to talk about, and Adam mentioned with fiduciary and PACE, is also who's ultimately responsible for those appeal decisions. Asking somebody to give you advice on how to handle an appeal is very different than them taking on fiduciary liability for those decisions. So you need to understand ultimately who does what and when and who's responsible for those decisions.
What Ron is telling you is to call us and order PACE, because that way you can outsource your final level appeal. In addition, if you want to, you could tie in first level appeals through our iService, pre-service appeals as well. So all this appeal piece can be outsourced out of your hands with a new revenue stream potential for your organization.
You know, another thing, and we've talked about it a few times, we've skirted near the topic, is the issue of stop loss. So one of the things when you talk about stop loss and appeals are, Technically, when you're deciding whether something is covered or denied by a plan, stop loss should play no role. You don't deny a claim because you think stop loss may deny it.
Right.
You can't let stop loss make that decision. However, at the same time, you absolutely need to keep stop loss in mind, not because they're deciding how a claim is processed, but because you need to keep them advised regarding the progress of the claim. Because if it is something that you expect them to reimburse, they need to be advised. Read the policy.
So I know we keep saying this, folks. I guarantee you, we could sell a Phia Group stop loss policy for a really cheap price, and thousands of you will buy it because no one reads the policy. We can literally have an exclusion in there that says we will never pay a claim, and bold it and put sprinkle down. We can sprinkle it with glitter, and they still will buy the policy. Read the policy. And then the most important piece on this is what you have there. Does the stop loss carrier's cost containment clash with the plans? This is a major issue we're seeing from a subrogation standpoint. We're seeing this from an auditing standpoint. Again, that's why, as Ron alluded to earlier, and I'm sorry for jumping the gun on this, those disclosure forms. If you are placing a stop loss, it's one thing. Cover that in the ASA. If a broker, an outside broker is placing it, you make sure everyone and their mother know that you're not responsible for any gaps or issues when it comes to the stop loss policy.
We do have a one-page disclosure for that in the instance where you're not the one underwriting stop loss, but there may be a conflict. Now, I've talked about keeping stop loss in mind when it comes to appeals, reading the policy to identify potential issues, and disclaiming any liability if you're not the one who placed it. You're probably thinking, Ron, it sounds like there may be a lot of conflicts that we need to worry about. What kind of conflicts are you talking about? Ta-da! Look at this final slide. These are just some examples of issues that we've been seeing. Actually, I want to give a shout-out to Travis McCucci, who actually called me this morning, and he brought up another potential issue that there may be out there. You're starting to see a lot of state-based legal requirements on the plan, right? Extended coverage and benefits.
My favorite one is the Medicare coding rules on network claims.
Yeah. It's all over the place. Plans are being required to pay certain amounts to cover certain benefits, whether it's by law or it's by a contract, right, a PPO contract. The point is stop loss, just because California tells you have to offer an extended coverage for pregnancy and family medical leave, it doesn't mean stop loss has to. So you need to read the policy to see if there's a potential gap there.
So just like John is our guru here in regards to our network stuff, Ron and I maybe train these guys too well.
I think so.
Because they're not better than us at these things. But Brady is our stop loss king. So Brady knows these issues, this is just this month. Like, we've seen every one of these in the past 2 weeks. This is not like, oh, it took us 18 years. No, folks. Rebate issue, who gets them? This month. Inadequate disclosure, right now. Mailbox rule, Ron, I think Ron's like a mailman. He gets these mailbox rule questions every single day. But Medicare coding rules, we just saw that last week. Yep. Ignoring PPO contracts that the plan is subject to, we see these all the time. So these aren't just like, oh, yeah, you see that once in a while. No, we see these all the time.
I think the bottom line is, if these limits and rules are in the policy, they're allowed to do it. The carrier is allowed to apply these rules, and if you're first learning about them after the claim has already been paid, it's too late.
We got a bunch of questions that we're not going to have time to answer. Here's what we can tell you. The slides are available on our site. Done. In addition, next month, October 18th, we are going to focus on the PBMs. We're going to focus on what the interesting move by CVS to try to lower the overall cost of high-cost claims. Whether you think it's a good one or a bad one, stay tuned. We will have detailed opportunities and options for you at the next webinar, so please feel free to join us. As these cases come out, a bunch of people are asking us about cases that have not come out yet. We're going to answer them as they come out. We make a promise. But, so, October 18th, 1 o'clock Eastern Time, on behalf of John Jablon, Brady Bizzaro, Ron Peck, and myself, Adam Russo, trust me, we are humbled by the thousands of you that dial in every single month. We don't know why you do it, but we appreciate the fact that you do it. We'll see many of you at SIA, and if not, have a great month. See you in October. Have a great day.